This is an orientation for supervised legal research. I think supervised legal research is a vehicle. I think uh, publication is a vehicle, but we have a larger goal when we deal with legal issues, and that is to change law to make it better. So don't stop, um, as some of your supervising lawyers will say, we know you just want to get this over with. That's not the correct attitude for supervised legal research. For supervised legal research, you say, I think I can change the world, and this is my opportunity to do it. Okay? All right. As I was saying, writing is not the goal. And we're not doing this because we want to graduate. Yun yung minimum. And I don't understand why you would skip the opportunity to be bigger, to use that opportunity to make a bigger impact on the legal community. And for some of you, that might be the only opportunity because you're going to practice in a way that's obscure, or you won't pass the bar, and that's okay. Remember when you thought that passing the laya meant it's a sign from God? Okay? Not passing the bar is the other sign. It means go and be happy and do something else. Okay? So academic writing does not need to be limited to the academic. That's what I've been trying to say. Change the world. Okay? What do I mean by legal academic writing? When do you use it? Okay, there is an issue that implicates the law, and that problem requires analysis and recommendations from a legal perspective. And I say this now because every year we assess uh, papers for the awards during graduation. And in this last batch, I my initial reaction on these articles are barely legal. I don't mean that barely. I mean barely. It barely contained any legal analysis. So it made deciding the winner easy because there's only one that actually used the law to resolve the problem. The others read like feature articles in a Sunday newspaper magazine. That's not what you're writing. You're supposed to be approaching a legal problem and solving it or resolving it. Okay. What you don't do, and no, I said this earlier, but treat the course as an opportunity to make a positive change in the world, and it is your track to immortality. Because once it's published, it's always there. And if it's really good, then they'll never forget you. What is our goal? Is to produce a treatise on the issue. Okay, it is a publishable work of scholarship, and it has to affect public policy or change the direction of the law. What you're not doing, I hope, is writing a column or a blog, because anyone can write a blog, especially these days. You're not writing a survey of cases. First year law students can write a survey of cases. You're bigger than that. You're smarter than that. You're seniors, right? And you are not writing a primer for a law. First, college students can write a primer for the law. So it doesn't require the training that you have been receiving for the last 4 years. It has to require an application of what you've learned. Right? So don't insult your professors by turning in something like this. Right. I've read, there's this article by Rebecca West that talks about what legal academicians do. And that is to write, to clarify, to criticize, reform, restate, describe, or analyze legal commands. Diba? They do so toward the end of making those commands better commands, more efficient, perhaps, or more in keeping with sound policy. It is normative in that sense. It is to tell the world what ought to be, what is the right thing to do when you have a legal problem. You don't write ways to escape AMLA. That's not legal scholarship. Diba? You don't write ways to enforce sexual rights according to Senator Padilla. Because right now I have no idea what he's talking about. You don't want to cite him and say we should have sexual rights over our partners. Of course not, because there's the way the laws evolved is exactly the opposite. To ensure that our partners are not our property, right? But so your goal is not to go back to those dark ages where women did not have a choice. Don't do that. That's not your function. That's not the function of legal writing. Right. So a lot of academic legal writing aims for justice. That's what I mean. It does so furthermore in some of the same ways with the same seriousness of purpose, etc., etc. But whether small or large in ambition, academic legal writing that more or less takes the form, the law is X and should be Y. And this is what I was talking about when I said it should be normative. Their function is to fix it, to illustrate how it can be fixed and why it should be directed in a certain way. It aims to make the law better against some metric. So that's the function of academic legal writing. Okay? So you have to find a genuine issue. And I think that's my purpose here. Okay. Why do we have law reviews? Can you see that my focus is not on the writing, it's on the fact that you've already published. Okay. And if you're aiming for publication because you want to become more relevant. Okay, these are platforms for the publication of historical and analytical legal research and writing. They provide the platform on which ideas can be born, develop, grow, and become recognized by others or changed or modified by others. They provide a platform for many thoughts about the law. So it is, let's say, part of the marketplace of ideas. You put your ideas out there, people read them, then you converse, you have a dialogue, and then you move forward to a better world. Courts are limited. The courts cannot do this because they are limited to addressing real cases and controversies. Lawyers address the issues raised by clients. Scholars are free from these boundaries. In fact, our lens is wider. We are not representing any client. We are looking at the state of the law. That people working on articles are thinking through legal issues and social issues, which may lead to ideas that reform the law for the better and may lead to new and creative laws in emerging fields or areas of law. This thinking and writing about it once read may ignite thoughts in others. It's a dialogue. Okay? So you become part of the conversation and hopefully your writing triggers it or moves it forward, not brings it back. Okay. See, in the US, law, legal academic writing talks about why we write. There's a whole bunch of it out there. Law review articles help practitioners, judges, professors, law students, and others studying the law to understand the law and to consider and evaluate arguments about the law as they work on real cases and controversies. In the US, they cite law reviews to a larger extent than they do here. Secondary sources, such as law reviews, are at the top of the list for most researchers who are trying to understand an area of law either for the first time. Sorry about that. Third, law reviews provide opportunities for law students to develop and practice skills that will be invaluable to them as lawyers. So that's why you joined the BLJ, because you're trained to write. And there is a certain way of writing a law review article, okay? Although the borders are porous, as I will show you in a minute. See, student editors will be better writers, editors, thinkers, and lawyers because of their work, hopefully. All right. So we know our function, we know our purpose, and there's some things I think that are important when we talk about selecting a topic, right? So what do we do now? How do I pick a topic? Well, one of the things I look out for is novelty. And the problem is, you may think that your topic is novel, but it's not. And that is why you're lucky, because it's so easy to check on the review of literature. What's been written? You have access to databases like Westlaw, you have Lexis, you have everything. Is the building falling apart? Oh, sorry. It's just coffee. She's really thirsty. You understand? Sometimes you have an idea, oh my God, can I sue a state for destroying the environment during an armed conflict? Then I found a book that's like 5 inches thick on that topic. Can I hold terrorists accountable for their actions? There's also a lot that's been written about that. Suing governments over climate change inaction. All you have to do now is follow the news, because all countries are ruling in favor of children against the state to compel their states to protect the climate, to do something about climate change. So you have to make sure your topic is new, right? Or else nobody will care what you're writing about. And there are so many new topics anyway. You'll never run out of them. Here's the other thing on emotions. Some of my students always say they don't want to appear emotional when they deal with a legal topic. And I say, it's okay. It's okay to be passionate about a certain topic, right? And that doesn't mean that you're doing the wrong thing, diba? An academic piece doesn't mean it is devoid of passion, and you will work better when you feel strongly about a certain topic, diba? It's like how many of you really feel strongly about corporation law at this point in your lives? Even if you plan to practice in that field, I don't see any serious issues in that field. So you don't have to be cold and dispassionate because the best writing are those that are the right to correct an injustice. That's cool. Legal writing ought to be cool. Here's one thing though. You cannot write if you do not read. This is supposed to be a separate slide, but it's right there. The I say this because most people, when you write the stuff that you've read, and the problem with fourth year students, law students, is for the past 4 years you've been reading Supreme Court decisions, which is probably the worst way to write. That's not, what is that? It just follows a certain form. I think that it's designed to make sure you pass the bar. And maybe unconsciously, they've evolved a way of writing that follow, that these are the issues, these are rulings, and it's not fun. And that's why you ought to read the US case law a lot, just to compare them. Okay? Okay. So where do we get our topics? Well, in the news. Well, for one thing, she's talking about, we have had confidential funds for a very long time. There are certain issuances that govern the use of confidential funds, but the vice president's actions during budget hearings triggered an interest in confidential funds because she asked for a lot. And she didn't, and the ones that she got, she didn't. We don't know how she spent them. So now the country's attention focused on her and how we use these confidential funds. Okay. Now this year she didn't ask for any because she didn't need the controversy. She didn't need the heat, right? Uh, but the office of the president still asked for a whole lot. It's getting bigger and bigger and bigger, and that's not something we study in constitutional law, not yet, until a case comes out. But that becomes a topic, right? Because you might be cited by the Supreme Court, not contempt. I mean, they might read your work, as the court has, diba? The Supreme Court cited Professor Sereno when she was, some of her works as a student, the Juan de Barrios, the IBP president. That's part of growing up. It should be on your checklist. Have I been cited by the Supreme Court? Okay. 403.46 million. This is not chump change, right? So it becomes an issue. We have the right to know. The issue now is whether they can take money from PhilHealth and all the other government agencies because they have to fund unprogrammed funds because they didn't put money for the usual projects that we have. They put money on their pet projects. So now there's no money for the regular stuff. And can you do this? Okay. Now, admittedly, in both these cases, both these stories, there are already cases filed with the Supreme Court. So when you take, I emphasize, it has to be current and urgent, diba? These qualify. But you run the risk of producing a paper that's a lot worse than the Supreme Court decision, right? And if it's worse than the Supreme Court decision, that's not a good thing. If you produce a work that it should overshadow the Supreme Court's decision, bigger, more complete, more accurate, more just, then that's a paper. Okay? What else is in the news? Oh dear, my dear. Actually, the issue to me is, can you do this? Can you use government money to publish your book or to distribute the book? No one even seems to be asking that question, diba? Because they got bogged down with personal stuff. May I know what the book is about? What's the answer? This person is a liar, and in essence, anything Senator Ontiveros says becomes an attack from Sarah's point of view. And she didn't answer the question. She just ranted and ranted about how ungrateful she was and how they helped her become a senator, etc., etc. But the issue there is, can you do this? The other question is it a book when it's only 5 pages? It's a comic strip, Your Honor. I need 10 million pesos to distribute a comic strip that now everyone has seen because people are sharing it in social media. So maybe we don't need to pay that. Yan pa lang yung sa budget, ah. Okay, because we have to move on. So, um, while there are always sources of, and yung sources, my favorite talaga is news. If you were my student, you know, you answered questions about current events. Right? Now, but you can also look at past events if they're still relevant. I don't see, di ba? I mean, some cases in the past, like when you do a retrospective, like when you analyze Haveliana after 50 years, like you analyze Oposa after 30 years, then that might be a relevant topic because you want to see how the law has changed, how the doctrines there have changed, if at all. You may not want to look too far into the future, right? And start writing about the ownership of gases in Pluto. And justify it by saying, yes, yes, but in the future we will go to Pluto. Yes, but that time nobody will read your work because the science has overtaken whatever brilliant insights you might have had then. But so it has to be current and relevant, diba? Who cares? Do you care? We don't even know if Pluto is a planet anymore. They keep changing their minds. There. So what kinds of papers can you write? Well, you can write critiques of cases, which is easy now because almost all Supreme Court decisions are wrong. Legal history of philosophy, you can trace the development of doctrine, also in relation to a case, diba? Like in the US, everybody knows, you know, that doctrine in international law, where in constitutional law, where the president is the sole, ano yung tawag yun? Sole, where's yung architect ng foreign policy. If you look at the origin of that, it's obiter dictum in the US. And yet we embrace it like it was it was doctrine. Diba? We always defer to the president kasi siya yung bahala when it comes to foreign affairs. That's not true. They laugh at that case. They laugh at that doctrine where it came from. So it can be a case from a historical perspective. There are areas where you can look at law and literature, law and economics, law and religion, law and stuff like that. You can also look at criticisms of legal scholarship, right? Write about writing. These are articles that make fun of law reviews. A law and economics critical hermeneutical policy approach and lots of other stuff that thousands of readers will find really interesting, and therefore you ought to publish your prestigious top 10 totally excellent law. It's a criticism of the culture of law review writing, including the length of the title. Don't give me, I had a student who revised her title 20 times and it's still 50 words long. No matter how she revised it, it's still long. I don't know what she just wanted to keep everything in the title. Like a law, the title doesn't have to contain everything, di ba? Okay. Before and after the colon, because almost all law review articles have a colon. I'm not kidding. See? She's got Betty Davis eyes, colon. Assessing the non-consensual removal of cadaver organs. Get it? They're hilarious. Get it? It's a song, Betty Davis eyes. They're talking about organ donation. It's hilarious. Plagiarism in law school, close resemblance of the worst kind. Do you even know how the pun works here? Thank you. Close encounters of the third kind. Law reasons copy wrong. Get it? There, colon again, plagiarism, process, and property. I just had so much fun looking for funny titles. Taxing polygamy, married filing jointly, and severally. Huh. This is the only time I like anything with the word taxation in it. Other criticisms. Look at this one. The shortest article in law review history. This is part of a body of scholarship called satirical legal scholarship, because they are making fun of the culture because it has to have footnotes. It has to have, the first time I wrote for a journal abroad, it came back. Well, first of all, they cut it by half. This was before the internet. I mean, there's internet. I'm not that old. There's internet, but you can't edit online yet. You cannot edit online yet. So they give you back your original article, and you can see they slashed it with red ink. It's like this is worthless, worthless. But you want to be published by Harvard, so you say okay. And uh, almost when you have a paragraph from a source, you have to cite every sentence. And we didn't know that. What we do here is write stuff and they put a footnote at the end of the paragraph. Apparently, that's not good enough. So it's an industry where they make you write all the footnotes, and it lengthens the article. And this guy is saying there is nothing of substance anymore when you look at law review articles. Puro form. Okay? And it's a footnote. The footnote is longer than the text. You think that given this expansive text, you can write an even shorter article? Forget it. The shortest article in law review history, abridged version, is already in the works. But this is published, huh? I mean, I didn't make this up. You think that's enough? There's a response. The shortest article, not so. Oh my God, Dixon. A response. All right. There's theoretical legal studies. I'm saying that, but don't do that to my class. It's only funny now, but it won't be if you try that with your professors. Okay. There you go. I like Jay-Z. It's a dildo in 49 states, but it's a dildo in Alabama. See, but you can say those words. I've seen squirting. If the government thinks it's urine, then they've got another thing coming. It's, I haven't read that in a long time. Or this one. Notre Dame published this one. The last journal I think Notre Dame published this one. And it's a history, it's a legal history because there are times when it became relevant in constitutional law. Can I come? Can I wear a shirt that says "fuck the draft"? Free speech. That a free speech issue in the U.S. when you are opposing the war in Vietnam, right? And then there's that case whose title I keep forgetting. The registered patent was FUCP. And can the government allow you to use FUCP? Because in fact, if you listen to the oral arguments, nobody could say it. They were arguing about FUCP, but no one could say it. And that was the problem, right? Because if you say it, it sounds like a bad word. So it was a trademark issue. I'm saying you also can be imaginative. I think because a lot of us tend to become conservative because we think law review writing, legal academic writing has to look a certain way. And maybe it doesn't. That's a real one. I can't remember. It's a critique of the law review culture as well. So there are law review articles there where they use art. Okay. And because I'm not to be outdone, I wrote my analysis of Poe as if it was a script. And I think I understand the case better now. And I'm the first Filipino to use the F word twice. Of course, it's redacted. And if you must know, that's my next article. One of these days, I'm really going to get in trouble. But I'm likening the Supreme Court decisions to a game of Calvin ball. And for those of you who don't know, it's a game without any rules. It's a game where you change the rules as you play. And if you'll notice, there's a copyright there at the bottom. There's a story there. Years and years ago, I asked for permission to republish this cartoon because there were just too many ridiculous cases in local government law. But the only thing I could think about was Calvin Ball. And then it never happened. It never materialized. And then like a couple of months back, I wrote to them again and said, can you still honor the permission? And I found the old email that says you may use it for free. And they said, okay, we'll honor it. We'll let you do it again. So there. I hope it comes out because I've never had a because I always wanted a cartoon ever since I read about the Red Hulk in Australian law reviews. The Red Hulk. And these are just some of the articles that well I cited them because this is a law school and I have to cite my sources, right? As you have to cite your sources. I think I can stop there and let the others speak and then we'll have a panel later on, right? Okay, thank you. Thank you very much.